Sorry for the slight delay. Engaged in animated discussion.
I was dealing just before lunch with the point that Mr. Perry had tried to make in criticism of the decision of the Supreme Court in relation to the question as to whether a source of funds had been paid.
Oh, I'm sorry. Slight confusion about our papers. Happily, Lord Kitchen is fully techno-savvy, as they say.
It's the modern world, my lord.
Yeah, well, we must all adjust to it, Miss Montgomery.
I fear so.
You're in a much better position than we to, well, apart from Lord Sales, of course, who's ridiculously young.
So, for those who have adopted to the modern era, this is in the electronic bundle at 1251. For those who haven't, it's in volume 3 at that same page of the record. And we're in the judgment now of the Supreme Court. And I was dealing with what was the personal interest that in fact was both alleged, we've seen that before lunch in the letter from the ICAC, but also what did the magistrates find. And you can see from line 20, they then deal with the suggestion that was made that Mr. Perry tried to say was justified by evidence that had no source of funds been identified, the government would not have been able to pay MedPoint within 2020. And as the Supreme Court correctly say in our respectful submission, there was no evidence to support that. Indeed, on the contrary, the decision was, as is clear from 1252, that it would and had to be paid in 2010 because of the existence of a budget shortfall in 2010, which made it possible, rather than the heavily overloaded proposed budget for 2011. And that appears, in fact, to have been the original understanding of the intermediate court before they came to make that statement as they did at page 23 of their judgment, because they recite accurately the evidence, if you don't mind going back now to volume 2 of the record, page 590, in the back at 590, which we're now in the decision of the intermediate court, they've set out the evidence of Mr. Jugnauth. And Mr. Jugnauth was the witness who said the minister had to approve this reallocation. And you can see, having set out his evidence at line 28 or 27, they say there was initially another source of funds from which the NGH project would have been financed, namely the Lotto funds.
I'm so sorry, which page are we?
590, my lord.
My fault, sorry. Yes, thank you.
Line 27, it begins at 27, so they set out in bold the evidence, and they make the point that in fact there was the source of funds up to the 23rd was the Lotto funds, and they explain, and indeed this was Mr. Jugnauth's evidence, that part of the reason they had to go to the minister was to release the Lotto funds, which is why we make the point that the Lotto funds would have been the default position had no decision been taken. It was the Lotto funds that would have led to the payment being made. And indeed that's confirmed at the bottom of 591, again at the bottom of that page, it'll be line 30 or so. The original contemplated source of funds was from the Lotto funds. Per Mr. Ramchurn, there are instructions from Mr. Yip not to use the Lotto fund, but instead to finance the same through the use of the Ministry of Health's identified savings. And it's that that leads him to draft the memo of the 23rd of December.
And at the bottom of page 590, when they talk about release of funds from the Lotto fund, does that mean release so that they can be used for other governmental purposes, or release so they could
release release the provision against it in the accounts, right, rather than release so it can be paid.
So in effect, yes, they could be used. They're not earmarked.
They could be allocated to something else. Yes.
Right, yes, I understand. Thank you.
Because, as I said before lunch, these are all just simply accounting fictions. The reality is there's a single fund that holds the government's money. The issue is really which book, which ledger, should these funds be entered into when they're dispersed.
So in a word, your case is that the funds were always there. They could have been made timiously from the Lotto fund, but it was decided, because there was a surplus in the Department of Health funds, that they would they would use that money.
Yes.
But if that failed for whatever reason, the Lotto funds were always there in the background.
So in effect, the memo is going up saying two decisions. Please authorise us not to pay out of Lotto funds, because that's what's been authorised now, and provide for the alternative that it comes from the Ministry of Health. So there simply wasn't an option of not paying, and there was never a point where there was not a source for the funds. It was either Lotto or the Ministry of Health.
And you're building on that point, you say that not only was the respondent's sister, not only did she not have a personal interest in all of this discussion about funds, I mean, she was entitled to assume a position of supreme indifference to it all.
Indeed, as was the company. So it does. I don't even need to get to the point of the sister not having an interest. The company simply had no interest. So far as it was concerned, the transaction was completed. It was entitled to payment, and it was entitled to assume that it would be paid. It was a matter of complete indifference, I would respectfully suggest, to the shareholders and the directors of the company, which fund the expenditure was allocated to as a matter of the government books and ledgers. So there simply was no evidence, as the Supreme Court rightly said, that there was any difficulty in identifying a source of funds, or indeed that there was any urgency, and Mr. Perry has already accepted there was no evidence of that urgency in any event having been communicated to the respondent. I should just correct one point in case he comes back to it. Mr. Perry's given you some references to the 2011 budget and the fact there wasn't any headroom in the Ministry of Health budget for 2011 to cover this expenditure. I think it is clear from the evidence that, in fact, the need to go back to the National Assembly had disappeared by 2011 because, to use the jargon, and you'll find this evidence at page 265, I don't need you to turn it up, but by 2011 the government had moved to what was called programme-based budgeting, so they no longer allocated specific items of expenditure in relation to specific projects. They simply allocated an amount to a programme, and then it was a matter for the department as to which projects they populated that programme with. But that's probably a point of Mauritian government financing that your lordships may not ever need.
Sorry, what was the reference again?
It's, my lord, 265. It's the evidence of Mr. Yip.
Yeah, thank you very much.
So, in our submission, it is crystal clear that the decision, not only as charged, was a decision that was concerned only with reallocation, not identifying funds. The evidence that was called established that it was only a decision in relation to reallocation rather than identifying funds. And that then brings us on to, if that is the decision, and indeed the proceedings, because as I say, that they were, both were identified as effectively focusing on the decision on reallocation, what was the evidence that the respondent knew that his sister had a personal interest in that decision? And the answer is none. And none is identified by the Intermediate Court. Now, I appreciate that Mr. Perry has made submissions saying that one can see that the Intermediate Court are making decisions about the respondent's knowledge, but they're making decisions about his knowledge in relation to matters that don't form the actus reus of this offence. They merely make decisions about whether he knew or ought to have known that the decision affected Medpoint, and whether he knew or ought to have known that his sister had a shareholding. Neither of those two would be sufficient to establish the critical factor, which is that he knew that his sister had a personal interest. And that would be difficult for two reasons. One, because as a matter of fact, his sister had no personal interest and could have no personal interest. But two, they don't make a finding in any event to that effect. So if I just go back to the intermediate court judgment, just to make good that proposition, that there is no finding that is capable of being rescued from that judgment that would enable this court to say, contrary to the views of the Supreme Court, that there was a sufficient factual analysis to reach a safe conclusion that the respondent had the necessary guilty mind. It's worth just looking again at the judgment, which your lordships have in volume 2, beginning at page 576. And it's worth noting, it's probably not my best point, but it's nevertheless a valid one, that the court's analysis, both by the underlining you see of the charge at page 576 and the elements which are repeated again at 594, do not focus on the mental elements, which in fact are not cited there at all. The charge that this behaviour was willful, unlawful and criminal, and you can see that that's simply been left out of the analysis, both here at 576 and at 594. And when they come to the critical points upon which Mr. Perry places emphasis in terms of analysing the respondent's knowledge, we can see, which is at 601 and 602, firstly at 601, Mr. Perry, as I understand it, relies upon the statement there that the intermediate court found as a responsible minister he cannot be believed when he stated he didn't consider the other folios before putting his signature on the request. That doesn't appear to be a finding that he necessarily would have looked at the relevant ones with Medpoint. Indeed, as you can see, they go on to say, be that as it may, irrespective of the fact that minute 6, that's the one he signs, does not mention the word Medpoint, the accused's attention ought to have been drawn by the fact that the minute was about NGH and he should have declined to sign and approve. That does not appear to be a finding that he knew, firstly, that it related to Medpoint, but more importantly, secondly, that it was something in which his sister would have an interest. And if you go over the page to 602, the other passages which are relied upon by Mr. Perry are firstly, after the line 4, that they state the accused was fully aware his sister was a shareholder as well as having an interest. And you then, in the next but one paragraph, you have this: unfortunately, the accused's reckless attitude when the decision to reallocate funds so as to enable payment in which company his sister has a personal interest led to the commission of the present offence. Now that falls significantly short of a finding which they would be bound to have come to, not that he ought to have known or was reckless, but that he did know that the decision, the reallocation decision, was one that gave rise to a personal interest on the part of Medpoint and necessarily on the part of his sister.
Well, there's a danger of the arguments running into each other here. Your principal argument is that she didn't have a personal...
Indeed. So
all of this is by way of...
Anyway.
Yes. All of this is by way of alternative.
Yes.
But your argument, as I understand it, amounts to the proposition that if it can be said that she had a personal interest in the particular decision under scrutiny, that the evidential basis for that is simply lacking.
Indeed.
Okay, well, I think we have that.
Indeed. And it may therefore not be relevant so far as the opinion of the board is concerned as to whether the intermediate court had not dealt with mens rea or had, in this rather curious way, dealt with it, as it were, by
the only possible relevance is if we respond to the invitation to give guidance for future cases.
Yes.
It may well be relevant for us to say something about this.
On that point, could I ask whether paragraph 63 and 64 of Mr. Perry's case have any matters on which you take issue? Just setting out the requirements of the actus reus and mens rea, as they maintain.
No, as I said, so far as the actus reus is concerned, I've made submissions about personal interest, about which care must be taken. So far as the mental element is concerned, I would accept that what has to be proved is effectively that the defendant acted knowingly in relation to those elements.
I mean, in paragraph 64, Mr. Perry says mens rea is either intentional or recklessness.
Yes.
But I think it becomes clear as one goes through what he calls the factual circumstances, yes, in 1 to 3, that, yes, what he means is knowledge or recklessness as to whether such a state of affairs exists.
Yes.
And it's in relation to the conduct element, yes, that you need intention or recklessness. Yes. Would you accept that as
yes, provided we're talking about subjective recklessness, that is,
yes,
realising that you are in a conflictual situation and nevertheless going on, even if you might, for example, think you have some excuse for doing so. But
because there was just something you said that in relation to the findings at page 602 by the Intermediate Court, which I wasn't quite sure what you intended us to take from it. You say there wasn't a finding there that the respondent, yes, knew that the matter related to MedPoint, yes, but it might have been said, yes, well, he knew that MedPoint were the contracting party in relation to, yes, the NGH. He knows this matter relates to NGH. Yes. If awareness of his sister's personal interest turned upon him being aware that actually this is all about MedPoint, I would have thought that would have been something about which the Intermediate Court could say he was reckless, even if he didn't.
Yes. The only reason I'm in any way hesitant about it is that obviously you appreciate there's subjective recklessness and objective recklessness. We're clearly in the subjective recklessness territory here.
Thank you. Yes, I understand.
And the only reason I'm nervous about that is because the way in which the Intermediate Court approached it was to say it's what the reasonable man makes of it, not what the defendant makes of it. So there was a real danger that what they're describing in terms of what he ought or ought not to have done is actually premised upon their reasonable man's viewpoint, the objective subjectiveness, which has effectively now lost much of its currency in modern criminal law thinking. But provided they're talking about subjective recklessness, that he knew of MedPoint and he knew enough of the MedPoint or NGH transaction to know the two were linked, that would be sufficient, yes.
Thank
you. The absolute core of what we submit is the correct approach to the judgment of the Supreme Court and the Intermediate Court is actually what's contained in the judgment of the Supreme Court, starting at page 1269. where the Supreme Court make a couple of points. The first is the one they make at line 12 on 1269, that so far as the Supreme Court was concerned, any evidential analysis had to take into account the fact that the respondent had formally abstained from dealing with the matter when he was aware that MedPoint was involved, and therefore any evidential analysis had to consider whether it stood to reason that he would deliberately get himself involved. And they then deal with the submission that nonetheless he must have satisfied the intermediate court that he had the necessary criminal intention. And if you turn over to page 1270, we can see at the top of the decision, they say that in that first paragraph, I'm paraphrasing it, effectively all that they find is knowledge that she is a shareholder. What they don't find is that she had a personal interest in the decision to reallocate funds. And indeed, they make the observation at the bottom of that page in the last full paragraph, it's highly questionable whether the appellant had the requisite guilty intent when he participated in a decision limited solely to reallocation at a point when MedPoint were already lawfully entitled, the more so when this was done at a time and in a situation where there was a total absence of any competing interest or conflicts of interest. So in summary, what they are saying is even if one gets to a point where there might, for some theoretical reason, have been an interest, it would be illogical, given the factual matrix, to think that the respondent would have involved himself knowing that to be the case. The much more likely scenario is that he would involve himself merely because it appeared to be, on the face of it, a reallocation of funds in which there could be no interest either in MedPoint or his sister.
Particularly against the background of his earlier recusing himself.
Exactly. Exactly. And indeed, even when Mr. Perry suggested that perhaps the case could have been remodelled so as to make his involvement in some way date back to earlier proceedings, the reality is, as I said to you when I opened our case, he had no involvement with this until the 23rd of December, until this memo comes across his desk. So the alternative case simply would have no evidential basis for proceeding. Could I then just, staying with the Supreme Court's judgment, go back to the criticism that Mr. Perry makes of its approach to the distinction between corporate and personal interests, effectively at page 1251, where they look at the decision of the Intermediate Court, and in particular the statement that the Intermediate Court had made at page 596, if you want the cross-reference, that it goes without saying, this is the Intermediate Court, it goes without saying that the accused sister had a direct personal interest in whatever decision affecting MedPoint. Now, it is that sweeping statement which we submit the Supreme Court were right to criticise. It does not go without saying that a shareholder, even a substantial one, has a direct personal interest in any decision affecting the corporation in which they are a shareholder. Far from it. The approach of the Supreme Court is correct because, as they point out, at 1251 line 12, that finding is generalised and ignores the need to analyse and assess each specific decision individually to determine whether the sister has a personal interest in it. So my Lord Kerr gave me the example of the decision to sell the hospital. Clearly that is capable of individual analysis so that you can get to a point and say, well, a 30% shareholder would have a personal interest in that. But if it's a decision, let's say, to change the month in which it files its annual accounts, and it goes to the government and seeks permission to do that, clearly an individual shareholder couldn't care less about that decision. So the complaint that is made correctly in my submission by the Supreme Court is the sweeping assumption that you can equiparate directly and for all purposes any decision that affects the company as being a decision that also is of interest to the individual shareholders. That can't be right. It can't be right both as a matter of law. I don't need to show your lordships pressed, but it can't be right as a matter of fact, because the character of the decision that affects the company will vary, and therefore the impact on the shareholder will equally have to be assessed properly in its own factual context. So
I think that Mr. Perry's argument might be put thus, that this legislation provides a prescription and it draws distinct lines as to where transgression is not tolerated. And in this case, although, as I put to you earlier, on one view, it would be a matter of indifference to the company and to the respondent's sister as to where the source of the funds was coming from. But it certainly was in the company's interest that the funds be paid, and that a decision as to their source is therefore something that would animate the interest of the company, because unless the source is identified, the payment cannot be wholly assured. And to that extent, there was, albeit at some remove, an interest to be identified on the part of the respondent's sister. And because of the necessarily strict drawing of the lines in this legislation, the respondent ought to have stayed severely away from it.
yes, and the difficulty with that is that it assumes that this decision did affect whether they got paid or no, whereas it didn't. All it did was say, I'm asked to authorise it not being the lottery fund and to authorise it being booked to the Ministry of Health. There was never an option of not paying or not allocating it. It was, as I said to my lord, it was either or.
Well, yes, quite, but I mean, it's still a matter for some passing interest, is it not, on the part of the company, that they are going to get paid and that the necessary procedures to ensure that they're going to get paid are undertaken. In a way, they were not in a position to influence whether it came from the Lotto Fund or whether it came from the Department of Health budget or whatever. They had a contractual right to enforce the payment. But I mean, if you're looking at a charter which is designed to stamp out corruption in all its manifestations, there will be hard cases. And this, it might be said, is a hard case because the interest on the part of your client is oblique. But nevertheless, if you recognise the nature of the charter, the drawing of these, one hesitates to use the word red lines, but nevertheless the firm lines nowadays, is an indication to him that he should leave this severely alone and at least explore the possibility of someone else authorising it so he can be removed from the entire operation.
Well, certainly, I accept step one in Mr. Perry's analysis, which is that this is intended to deal with both the existence of corruption and the concerns of the people of Mauritius about corruption. Where I would respectfully differ from him is in saying that you can look at interests as if they were some sort of construct and say, well, the company ought to have been interested in this. In fact, there's no evidence the company was even aware that this was part of the process, still less that it had taken an interest in it. this is something that is completely obscure so far as the company is concerned. All it knows, and we've got the exchange of letters, is it's been written to saying, we offer so many rupees, and they've written back saying, we accept. And so far as they are concerned, that this operation within government is not only a matter of indifference to them, it's completely off their radar. So at the very least, one would think that when your lordships express the views that you do about what may be a personal interest for the purposes of the Act, it can't be a construct. Well, they would have been interested if they'd been told. It must be an actual point of fact in which the person has a real interest.
I mean, in your case, even if the respondent had a 30% interest in MedPoint, so that it was an associate.
Yes.
You would say that MedPoint still doesn't have an interest in this.
Correct.
Personal interest.
Correct. Correct.
I mean, he'd be fairly unwise to put his name to
I
a
agree.
decision involving MedPoint. You say it wouldn't be caught by this.
I agree, and it's that element of the lack of wisdom of becoming involved, which the Supreme Court regard as pointing decisively towards the fact that this can't have been a case in which he appreciated there was any interest either by MedPoint or his sister, otherwise he wouldn't have involved himself, having scrupulously recused himself from the decisions in Cabinet and the earlier decisions about when it should be paid, which were being bandied around the ministries in September, October and November.
Right. Well, where are we now?
So we are at the point where I am saying you cannot simply read through a corporate interest to say that an individual shareholder's interest must be equally engaged. That's the only point that I'm making. So even if MedPoint had got wind of the fact there was some reallocation and took an interest in it, you couldn't then say necessarily the shareholders will take an interest in it. In that case, the shareholder, as with a lot of corporate activity, may well say, well, it's a matter for the corporation to follow up. I personally don't have any interest in it. Government's made a contract. MedPoint will pursue it and make sure it's paid. It's not my personal interest that it should be pursued in any particular way in relation to the budgeting of the government. So that you do just have to take these things in steps rather than, as the intermediate court did, simply cross the river with one bound. Anything the company is interested in, the shareholder is too.
Right.
So, my lords, I would respectfully suggest that however the appellants now seek to cast this case, the reality is that the evidence before the Supreme Court fully justified their decision that the case had not been made out either in relation to the actus reus, namely that there was a personal interest, or in relation to the mens rea, that the respondent knew that there was that personal interest. They are entitled as a reviewing court, as this court will appreciate, to analyse the facts. And although they obviously have to defer to the advantage that the magistrates in the intermediate court have of having seen the witnesses, they are nonetheless under an obligation themselves to form a view on what the evidence established. And in those circumstances, their conclusions that this case was simply not made out, there was no evidence of a crime being committed here, is one, firstly, that your lordship should not interfere with, but secondly, that your lordships, I would ask, not to try and reformulate the case in the way that Mr. Perry had, so as to cast doubt upon the behaviour of this particular respondent.
Ms. Montgomery, am I right in thinking that you would not necessarily be assisted by the fact that there was no appreciation of a personal interest, and that what really matters is the knowledge of the underlying facts?
Indeed, indeed, yes. Can I assist any of your lordships further?
Don't think so. Thank you very much indeed, Ms Montgomery. Ms Buckley? Yes. Mr Perry?
Thank you very much. Lord, may I just deal with some of those points that were made at the conclusion of my learned friend's submissions? First of all, the point made by my Lord Lloyd-Jones in relation to you don't have to know it's a personal interest in the law, you have to know or be reckless as to the facts. There is also another point in relation to this, because my learned friend has been making submissions in relation to knowledge on the part of the company or the sister. With respect, the knowledge of the company or the sister is not part of the mens rea ingredient of the offence.
Knowledge of the respondent.
It's the respondent. A public official can't avoid liability under this legislation by showering his relatives' companies with contracts and then saying they didn't know it was me. That would be a pretty extraordinary Prevention of Corruption Act. That is why you have a conflict of interest provision. This is the point being made by the Select Committee. It is the problem of proving corruption. Because to prove corruption, it is ordinarily said there must be a quid pro quo. There must be something for something. Now, if you haven't got the something for something, it's not corrupt. So what my learned friend is doing is importing into a conflict of interest provision which is designed to avoid that very evidential difficulty, a quid pro quo provision, knowledge on the part of the company or some form of knowledge. That's irrelevant. All that matters is whether the ingredients of the offence are made out in relation to the public official. And if it were necessary to show that the sister or the company were aware of the personal interest, then the legislation is simply a dead letter. The corporate personality point, if I may just make some short submissions in relation to that. First of all, it would be to inject into criminal proceedings in Mauritius real difficulties if the corporate personality point depended upon a case-by-case analysis. Because no doubt the courts of Mauritius would be confronted with arguments of the type presented to your lordships. Suppose there's a mortgage, suppose the company is in debt, or suppose it's about to be wound up. Section 13.1 tells us there is a simple rule of having an interest, and it's a shareholding. And the associate point is not the answer. And in fact, the associate point, if it is the answer, leads to absurdity. And the point I'm going to make now is that 13.1 and 13.2 operate coherently, not as my learned friend has suggested with 13.1 being wider than 13.2, but they operate in tandem. That's why they're in the same section. Now suppose there is a company which the public official wholly owns the shareholding. Now, we made this point in paragraph 117 of our respondent's case, but we fell into error because, as my learned friends rightly point out, you would nevertheless be caught by the associate point. But it would be slightly curious if the interest is the interest of the associate rather than the public official. So in other words, you've got a public, if my learned friend is right, and it's, you have to get in there through the associate route, on the basis of the Supreme Court's decision, the minister, even though he's got 100% shareholding, subject to the facts on my learned friend's case being investigated, would have no personal relevant interest for the purposes of section 13.2. But it is presumed that he would have a direct financial interest in the company which would trigger a disclosure obligation under 13.1. So on our case, on the alternative, taking a definition of personal interest which is not artificially confined to proprietary rights, The minister clearly has a personal interest which exists in addition to any interest that an associate has. In the same way that all that minister, public official, relative and associate are doing are identifying the individuals or entities who are within the section. It's not saying that you can only get into 13.2 by an associate. May I just
In other words, the relative provides the connection,
yes.
but the interest then becomes personal to the decision maker.
Yes. But Lord, may I just give your lordships an example of the absurdity that follows if the analysis which is being presented to your lordship is correct. Suppose a public official owns 20% of the shares in a company with which a public body proposes to deal. So he owns 20%, but he's not a director or in charge or control of its business affairs. It's just a 20% shareholding. On the Supreme Court's analysis, an offence could be committed under Section 13.1 because it's over the 10% threshold for 13.1, but 20% doesn't apparently get you into 13.2. Now, why would you be required to disclose an interest for 13.1 and then be permitted to make decisions in relation to the very deal that you've been required to disclose? That would be incoherent. And it may reasonably be assumed that the National Assembly did not intend incoherence and for these provisions to operate in a way that would call into question their efficiency in holding to account public officials who engage in transactions which create suspicion. Now, on the appellant's case, the 20% shareholding in a company illustration, clearly the public official has a personal interest in decisions affecting the company as well as a direct interest in the company. So you get to a direct interest and a personal interest. So on our case, in that 20% example, there's a disclosure obligation and there's the total prohibition on becoming involved in decisions which impact on that company.
But theoretically, that could be activated even if it was a less than 20% share.
Even if it's less, my lord, even if it's less. Because the whole point of it, my lord, I respectfully agree. I mean, this is the difficulty with the argument and the analysis of the Supreme Court. What are we then to investigate? But there's a bigger problem. There's a bigger problem that arises. And the bigger problem is this. All right, you've got to have something more significant than a mere shareholding. Well, where does that leave the mens rea? Does the public official have to know there's a mortgage? Does the public official have to know that they're indebted to the bank? Does the public official have to know that the contract isn't going to be worth very much in terms of what it leads to in terms of a dividend to that particular shareholder? That would be an impossible provision to police and operate. It would cause trials to become unwieldy and issues to proliferate. That is not what this section is designed to achieve. It's designed to be a crisp, simple exclusionary rule. You shall not pass that line. You shall not cross that line. Now, in this case, the defendant did cross the line. Now, your lordships have been addressed on the basis that there should be deference to the Supreme Court. With respect, the Supreme Court was not the court of trial. The court of trial was the intermediate court, and the intermediate court found that the respondent lied. He lied when he said he hadn't seen minute 5 and 5A. Now, what implications does that carry for his culpability? Because the intermediate court were entitled, they saw and heard him give evidence. They saw and heard him give evidence about why he was making the decision, and they rejected his evidence, and they found he was to be disbelieved. Now, any trial court, if you disbelieve the defendant, you're entitled to say, well, once his credibility is gone, that's something that's generally relevant to his state of mind in relation to the rest of it. Now, my lord, what I would say in relation to that is if my learned friend's submissions to the Supreme Court and the Supreme Court's acceptance of those submissions were correct, that in fact the intermediate court found this to be a case of absolute liability, why on earth were they making any findings about his credibility? They should have said, when they got to that point, the prosecution have said, he's not told the truth on this, that's irrelevant. They don't.
But they were examining alternative scenarios, I suppose.
Well,
be the benevolent view.
And they were entitled to do that. But the suggestion that there should be deference to the appellate court that's effectively interfered with a finding of the intermediate court in relation to credibility, we would submit is to turn the ordinary principle on its head. And the reason I say that is this. The Supreme Court said, well, he'd recused himself from the cabinet decisions, and surely that's something that's to be taken into account. The intermediate court knew all of that, but they were entitled to come to the conclusion, we disbelieve you when you say you didn't see these minutes. So we would submit that if there is any deference in this case, it's to be afforded to the trial court and not to the appellate court that was doing, no doubt, its best off the record, which is no substitute for seeing and hearing the witnesses, how they give their evidence, and the tone and tenor in which they deliver it. So that is that. So far as personal interest is concerned, we made our points in relation to the adjective personal in our written case. Of course, we accept that personal is a limiting provision and it excludes matters of a general nature. But even if you say it excludes matters of a general nature, that's not this case. This case is of an interest in a corporate entity that was to receive a significant amount of funds from a government source approved by the brother of one of the principal shareholders of the company. The apparent bias test, I don't accept, we don't accept with respect that the intermediate court confused the issue of apparent bias with the ingredients of the offence. I've made our submissions. They were discussing Anne's, Porter and McGill, and apparent bias in the context of, first of all, the mischief at which the legislation is directed, and they were correct, and secondly, that you don't have to show actual bias, but that was after they'd found the ingredients of the offence proved. So far as the evidence as to the payment is concerned, if I may, with respect, my Lord, I respectfully agree with your Lordship's summary of the way that we put it. The source of the payment was not all that was an issue in this case, as the information itself at page 9 made clear, the reallocation to so that MedPoint could be paid, to pay MedPoint. And this is just the sort of decision where there is a financial interest which should be off limits. And he should not have engaged in the decision at all, because inevitably it calls into question all the proceedings in relation to the MedPoint contract. Once he's there, it's infected. That's the purpose of the legislation. In relation to, your Lordship asked me this morning whether there was any evidence of the urgency of the decision, and the defendant wasn't cross-examined on it, but the urgency was made clear by minute 5, page 692, which the Intermediate Court found he'd read. And that's at page 597. Minute 5 is at 692, but the Intermediate Court referred to that at 597, line 22. If I may just look at 692 in the it's the second paragraph. To enable payment to be effected within fiscal year 2010. So that's minute 5. And that was, of course, one of the minutes that he said he hadn't looked at.
But that's, I think, something short of saying that if it wasn't possible to effect it within the fiscal year, that it wouldn't revert to the Lotto Fund.
I respectfully agree, my Lord, but in relation to the urgency,
yes.
And of course the Intermediate Court was looking at the evidence in its entirety, including the references to which I made reference this morning, and we'll submit them to your Lordships in writing. May I just say something in relation to paragraphs 63 and 64 of our printed case, which is the ingredients of the offence point, where your Lordships asked my learned friend if she agreed with our formulation. And just so that your Lordships are aware, we've never suggested that the recklessness to which we make reference is anything other than a subjective awareness of the risk that you may be acting where there is a personal interest. In other words, the recklessness here, we've never suggested it's an objective test, but that explains why the Intermediate Court expressed itself as it did. And it's the point your Lordship put to me a moment ago: does it need to be 20%? Well, no, it doesn't need to be 20%, but the defendant didn't know whether it was 100% or 0.1%. Now, once you know she's a shareholder, you are reckless because you are running the risk that she has a personal interest. That's the point. And actually, the more you read the Intermediate Court, we would submit, is the more coherent and the more understandable it is. The more you read it, the more you see that they considered it with great care, and they didn't make a finding of actual knowledge there. They made a finding of actual knowledge of the shareholding. He knew that she was, not as the Supreme Court said, he must have known. He did in fact know, because he said that in evidence, and he was reckless as to the amount. It could have been 100 for all he knew. So what was he doing? And even on my learned friend's submission, that you'd have to look at the facts, well, suppose he was reckless as to whether it was 100%. That's culpable. That's where the culpability lies. That's why the mens rea requirement of intention and recklessness are the paradigm requirements of culpability in criminal law. This wasn't a negligence-based offence, nor did the Intermediate Court analyse it in that way. And the point that we would conclude with, my Lord, is that one way of approaching this case is whether the arguments, if accepted, would provide an obvious means of evading the statute. And we would submit that that's a good touchstone and test for whether it could have been intended by the National Assembly. Would the construction that we are being invited to adopt provide an obvious means of evading the statute? Because I would submit that if that question is asked, then the answer to the points that we have raised become obvious, because to evade a statute of this nature with this purpose cannot have been the intention of the National Assembly. And in the circumstances, we would invite your lordships to allow the appeal, reinstate the conviction, and remit the matter to the courts of Mauritius for sentencing to take place. So, my lords, those are our submissions, unless I can assist you.
Well, I think you mentioned again that you intend to make some written submission.
Just the references, my lord.
References. How soon can you do that?
By tomorrow, my lord.
By tomorrow.
Yes.
And Ms. Montgomery must have the opportunity
Yes, of
to
course.
answer.
Yes, of course.
So can we give you a week in which
Yes,
to...
thank you, my lord.
So can I expect to have those in a week's time? Thank you very much indeed, Mr. Perry. We're very grateful to Council for the elegant and persuasive submissions in this case. And of course, we acknowledge that there are many who haven't spoken but have nevertheless contributed, I'm sure, massively to the preparation of it. It's an extremely interesting case and quite obviously a very important case for the state of Mauritius. So we will want to reflect very carefully on the arguments that have been presented to us, and we will take time, therefore, to consider our judgment, which will be delivered in due course. Court is now adjourned.